Affiliation or invisible bias among arbitrators is a challenge which is required to be addressed. Affiliation bias has been defined as cognitive predisposition to favor a party due to cause of appointment. It is not just restricted to appointment or nomination bias. In case of transnational disputes, it is broader and wider. There is empirical data supporting existence of implicit biases in a variety of settings. These can arise from sympathetic attitudes towards a specific group or certain beliefs. In case of affiliation bias, arbitrators, despite their best intention, remain biased and are primed to favor one litigating party. One of the challenges faced in international arbitration is practice of double hatting, where individuals act simultaneously as arbitrators and legal counsels in different cases. Performing multiple and sometimes overlapping roles can affect arbitrators' ability to act impartially and might hint towards impropriety. Double hatting also reflects lack of diversity, slower disposal of cases, and raises issues like elitism by thereby eroding public confidence. Double hatting is also closely connected with the repetitive appointment of arbitrators, wherein same arbitrators are appointed to hear multiple cases involving the same parties or related issues. While such appointments are driven by specialization and experience in the relevant field, it also creates a perception of bias, as arbitrators may be seen to favoring one party over the other based on their previous decisions. Repetitive appointments or double hatting results in lack of new or independent judgment and in fact forecloses their door for new and competent arbitrators. High cost of arbitration, arbitration, even in institutionalized and international arbitration, is a drawback which of late has been noticed and commented upon. The prevailing sentiment that administrative charges of an institution, arbitration costs, expert witnesses constitute majority of the financial outlay of the parties. Third-party funding in litigation and arbitration financing is also a matter of concern. The last aspect is soft laws, which refer to non-binding rules, guidelines, and principles that are developed by international organizations, arbitral institutions, and other stakeholders in international commercial arbitration. Soft laws are intended to provide guidance and best practices to both parties and arbitrators on issues such as arbitrators' ethics, procedural fairness, and conduct of parties. However, there are several apprehensions which cannot be overlooked. These might arise on account of lack of clarity, consistency, and limited accountability. Further, presence of several soft law frameworks might lead to overlapping, conflicting, and thereby resulting in dilution of effectiveness and potential abuse. What is seat of arbitration and its importance to international arbitration and domestic arbitration? The significance of seat of arbitration has been often highlighted across many decades of jurisprudence surrounding arbitration law. It is a core aspect of arbitration insofar as designation of a seat determines the courts which will have exclusive supervisory jurisdiction over the arbitration proceedings. That apart, the seat plays a crucial role, especially in international commercial arbitration, as the procedure for arbitration is normally regulated by the seat of arbitration, also referred to as lex arbitrae. Redfern and Hunter have encapsulated the importance of seat in arbitration as follows. The place or the seat of the arbitration is not merely a matter of geography. It is a territorial link between arbitration itself and the law of the place in which the arbitration is legally situated. The seat of arbitration is thus often intended to be the legal center of gravity. This view expressed by Redfern and Hunter was applied in Bharat Aluminium Company. Thereafter, again, by this court in BSG Soma joint venture, wherein it has been held, the concept of judicial seat of arbitration proceedings and its relationship to the jurisdiction of the court, which are then looked into by matters relating to arbitration proceedings, including challenges to the arbitration, was unclear and had to be developed in accordance with international practice on case-to-case basis by this court. Whenever there is an express designation of a venue and no designation of an alternate place as seat, combined with the supranational body of rules governing the arbitration and no other significant contrary indica, the conclusion is that the stated venue is actually the judicial seat of arbitration proceedings. Coming back to the practical aspect of choosing a seat, given its significance, it is advisable for the parties to themselves choose a suitable place of arbitration rather than leave it to choice of others. Herein, the question also arises when there is one dominating party or one party which is economically stronger. They normally then enforce the place of their choice as a seat of arbitration. But then there is another way of looking at it. Business entities logically prefer a stable, expected, and safe place in order to commercially contract and invest. While significant aspect of this atmosphere is decided by economic policies and economic status of the markets at the time, but there is a significant aspect of this atmosphere which would be legal dispute resolution place and efficiency thereof. And this is where the parties act choosing the seat of arbitration becomes pertinent. They look for seats which possibly are partial, if not neutral, with a robust arbitration framework, convenient enforcement mechanisms, in other words, safe seat of arbitration. This brings us to the next question: how to build a safe arbitral seat while accounting for domestic realities. It is almost as if we are revisiting an often debated topic. An annual stable in arbitration conferences in India. Is India a desirable seat of arbitration? And to see India in its trajectory as being preferred seat in international arbitration. How does a jurisdiction build a safe arbitral seat? There can be no straitjacket formula. Of course, there are certain aspects which are crucial in terms of the impact they have in the terms in which seat is perceived by the users. The three aspects which are important are: one, robust legislative framework and practice surrounding arbitration. Two, arbitration-friendly and pragmatic approach by the judiciary. Three, convenient enforcement mechanism. I believe that the aspect of robust legislative framework and practice surrounding arbitration is an aspect which India must take into consideration if it wants to become the preferred seat of arbitration.